Welcome back, everyone. Have you ever bought something online? Hired a service? Or simply promised to do something in exchange for payment? If so, you already encountered the world of contract law. But what exactly makes a promise legally binding? When does an agreement become a contract? Also, what happens when one party fails to keep their promise? In this lesson, we'll explore the law of contract from the ground up. We'll learn the essential elements of a valid contract, understand real-world examples, and discover how contracts affect our daily lives without us even realizing it. Whether you are a university student, preparing for exams, or simply curious about the legal principles behind agreements, this lesson for you. So, grab your notes, stay focused, and let's begin our journey into the fascinating world of contract law. What's a contract? The contract is an agreement between two or more parties that is intended to be a legally binding promise. The contract might be a legally binding oral or written agreement. The contract exchanges any combination of goods, services, money, and property. Normally, we can say the contract is a promise or promises. It must be legally binding to be a contract. If it is not, it's only an agreement. Look at this. This man wants to sell his car for some price. He is offering his car, so that's why we called him the offerer. Offerer offers a car for a customer. Now, what should the customer do? Customers can accept or not accept the offerer's offer. But in this case, the woman has accepted that offer from the offerer. She is ready to buy this car for the man's offering price of the car. Now, he can't sell the car for others because now it has a buyer. Now a promise has been made between them. This woman gives money to this man. After paying, the man gives the car. See? She gives money, man gives his car. Right? We can call it as consideration. Right? This man offer, this woman is accepted his offer. That's why we say acceptance, right? Okay. We can say offer to this woman because she accepted that man's offer. You can see that it will be a transaction here. See? If accept the offer, it has built a promise between the offerer and the offeree. A promise and considerations make an agreement together. We can represent it like this. See? If accept the offer, it has built a promise like this, right? Between the offerer and the offeree. So, A promise and a promise and considerations make an agreement together. When we add laws to an agreement, it becomes a contract. If something is to be a contract, it should have an agreement between two or more parties. Agreement can be oral or half oral or either written or half written. The contract must fulfill the intention of the parties. As I told you before, if an agreement has laws, it must be a contract. Simply remember, contract must have laws. What are the elements of a contract? First one, agreement between the parties. Second one, intention of the parties. Third one, forms or modes of agreements. Fourth one, legally and possibility of the object. Next one, capacity of the parties. If you are a lunatic, minor, drunk, insolvent, or married, those are the chief categories of contractual disabilities. Wait. The next topic is invitation to treat. Think in the advertisement, it is highlighted what they give as reward if a customer collects 1 to 25 numbers inside a chocolate cover. Think in the advertisement, it is highlighted what they give as rewards if a customer collects 1 to 25 numbers inside a chocolate cover. If a customer collected 1 to 25 numbers, the company should give the prize to the customer as the advertisement has the word reward. If something is an advertisement, display of goods, price tag, auction. In an invitation to trade, who is the offerer? The customer is the offerer. Invitation to trade means when we sell something while displaying items to a customer, we call it an invitation to trade. We invite to the customers. Please come and buy, right? Let's discuss one of the most famous cases in contract law. Mrs. Carlyle versus Carbolic Smoke Bowl Company. Imagine you see an advertisement. This is the advertisement, right? So, this is the advertisement claiming that a product can prevent influenza. The company even promises to pay £100 to anyone who uses the product correctly and still catches the flu. Sounds like a marketing trick, right? Okay, well, that's exactly what happened in this case. The Carbolic Smoke Bowl Company advertised that if anyone used their smoke bowl 3 times a day for 2 weeks and still contracted influenza, they would receive £100 as a reward. To convince the public that they were serious, the company stated that they had deposited £1,000 in a bank. A woman named Mrs. Khalil purchased the smoke ball and used it exactly as instructed despite following all the directions. She still caught influenza. Naturally, she claimed the £100 reward. However, the company refused to pay. They argued that the advertisement was merely a sales promotion and not a legally binding promises. The case eventually reached the Court of Appeal. The court examined whether the advertisement was simply sales puffery or genuine contractual offer. The judges concluded that the advertisement was a real offer. The statement about depositing £1,000 in the bank demonstrated that the company genuinely intended to fulfill its promise. The court also found that Mrs. Khalil accepted the offer by using the smoke ball according to the instructions. Furthermore, the inconvenience and effort she undertook in using the product constituted valid consideration. As a result, the court ruled in favor of Mrs. Khalil. The company's appeal was dismissed and they were ordered to pay her £100. The significance of this case is enormous. It established that advertisements can create legally binding contracts when they clearly show an intention to be legally bound. This principle continues to influence contract law today and remains a landmark case studied by law students around the world. The contract is an agreement between two or more parties that is intended to be legally binding promise. We can simply represent the contract like this. Let's discuss another case. Pharmaceutical Society of Great Britain versus Boots Cash Chemists. This case helped establish one of the most important principles in contract law, the difference between an offer and an invitation to trade. Let's start with the facts. In the early 1950s, Boots Cash Chemists introduced a new self-service shopping system. Customers could walk around the store, pick products from shelves, place them in a basket, and then take them to the cashier to pay. Among these products were certain medicines that by law had to be sold under the supervision of a registered pharmacist. The Pharmaceutical Society of Great Britain argues that Boots was breaking the law. They claimed that no sale occurred when customers picked the medicines from the shelves, meaning the pharmacist was not supervising the transaction at that point. So, the legal question was, when is a contract formed in a self-service store? Is it formed when a customer picks an item from the shelf? Or is it formed when the customer pays at the cashier? The Court of Appeal carefully considered this issue. The judges held that displaying goods on a shelf is not an offer. Instead, it is merely an invitation to trade. An invitation to trade is an invitation for customers to make an offer to buy. An invitation to trade is an invitation for customers to make an offer to buy. When a customer picks up an item and takes it to the cashier, the customer is actually making the offer to purchase the item. The store then has the choice to accept or reject that offer. The contract is formed only when the cashier accepts the payment. Because a pharmacist was supervising the checkout area, the court found that Boots had complied with the law. As a result, the court ruled in favor of Boost Cash chemists. The Pharmaceutical Society's claim was dismissed. This case established a key role in contract law. Let's discuss another contract law case, Fisher vs. Bell. Let's begin with the facts. A shopkeeper displayed a flick knife in his shop window with a price tag that read ejector knife 4 shillings. At that time, restrictions. Does displaying an item in a shop window amount to an offer for sale? The case eventually reached the divisional court. The judges examined an important principle of contract law. They explained that goods displayed in a shop window are not offers. Instead, they are merely invitation to trade. An invitation to trade means that the seller is inviting customers to make an offer to purchase the item. The actual offer is made by the customer when they enter the shop and request to buy the product. The seller then decides whether to accept or reject that offer. Because the flick knife was only displayed in the shop window and was not legally offered for sale, the court held that no offense had been committed under the Act. Therefore, the defendant was found not guilty. The appeal was dismissed. This case became a landmark decision because it reinforced an important rule of contract law. A display of goods, whether in a shop window or on store shelves, is generally an invitation to trade and not a legal offer. The significance of the case was so great that Parliament later amended the law to close the loophole identified by the court. Today, Fisher vs. Bell remains one of the most frequently cited cases when studying offer and acceptance in contract law. The acceptance is final consent or acceptance for the terms of the offer. According to this image, she likes to buy this car for this price. This is the car, right? I'm not perfect for drawings. According to the general rule, acceptance should be communicated to the offerer properly by the offeree. Example: telephone call, fax, email, letter by post, mouth to mouth. The next topic is communication of acceptance. Communication of acceptance. acceptance. The postal rule, where acceptance by post has been requested or where it is an appropriate and reasonable means of communications between the parties. Then, acceptance is completed as soon as the letter of the acceptance is posted, even if the letter is delayed or destroyed or lost in the post so that it never reaches the offerer. The next topic is considerations. It is the binding fact of a contract what is exchanged between the parties. What are the terminations of an offer? Acceptance, rejection, counteroffer, revocation, death, failure of a condition, and lapse of time. What are the terms and conditions of a contract? Conditions, warranties, exemption clauses, mere representation. What's a condition? A condition is a major term which is vital to the main purpose of the contract. If I breach a condition of a contract, what would be happened? First one, injured party can claim damages. Second one, injured party has direction to repudiate the contractor to go on with the contract. The next one, warranties. This is a less important term comparatively. If I breach a warranty, what would be happen? Injured party can claim damages but cannot repudiate the contract. The next one, exemption clauses. The aim of this clause is to limit or exclude the liability of one party of the contract where the contract is breached. The next topic is Unfair Contract Terms Act Exclusion Clause. If the person signs a document without reading or without understanding, the exclusion clause will automatically be a part of the contract. However, the clause must be brought into the attention. Reasonable notice must be given. What are the vitiating factors of a contract? Mistake, misrepresentation, illegality, and duress. The next topic is forms. Contracts void and unenforceable unless in a particular form. Example, Prevention of Frauds Ordinance number 7 of 1840 section 2, any sale, purchase, transfer, mortgage, and etc. First one should be in writing. Second one, in the presence and signature of licensed notary public. Minimum 2 witnesses. Third one, notary attestation. The next point, contracts void and enforceable unless in a particular form. For an example, promise to marry should be in writing. Motor vehicle transfer document MTS 6. Some forms of CEB, water board, bank is good. Under the discharge of contract, we have 4 points: performance, agreement, breach, and frustration. What are the remedies of breach of contract? Remedies for breach of contract: damages, specific performance, and injunction. That's all for today's lesson on the law of contract. I hope you now have a better understanding of how contracts are formed and enforced. If this video helped you, please like, share, and subscribe for more educational content. Thanks for watching and see you in the next lesson.